So I want you to just imagine this scenario for a second. Picture walking into your bank. You're there to check on a massive sum of money. We're talking essentially your life savings here.
Right.
And you've intentionally left it there for, over a decade, just letting it quietly accumulate interest in the background while you go about your daily
There's
life.
a lot of people do, yeah.
Exactly. But when you finally walk up to the counter to claim what is rightfully yours, the teller, looks at their computer screen, looks back at you, and says literally the absolute last thing you ever want to hear.
Yeah.
I'm sorry, but you already withdrew this money years ago.
Oh, wow. I mean, it strikes at the very core of why we even use banks in the first place, doesn't it?
It really does.
Because the entire global financial system, it's really built on this invisible foundation of trust. Like if you hand a massive institution your money, you're operating under the assumption that their internal records are basically flawless,
Yeah.
that your wealth is protected. So when that trust shatters, it creates a very real panic.
And that panic is exactly what we're getting into today. We are taking a deep dive into a fascinating 2025 Supreme Court of the Philippines decision.
The Antonino case.
Yes, Antonino versus Banco de Oro, or BDO. And we're going to unpack this whole dispute over missing time deposit investments, a highly suspicious signature, an airtight alibi, and this is the crazy part, this ultimate showdown between a massive bank's computer system and a depositor's physical proof.
And honestly, if you have money sitting in a bank account right now, the legal principles in this case, they directly affect you.
Oh, absolutely.
The whole dispute really revolves around a standard of care known as the highest degree of diligence. So we are going to examine just how far a banking institution is legally mandated to go to protect your deposits. And, well, the heavy financial penalties that drop when they fall short of that standard.
Right. So let's start with the timeline, because the series of events here involves a pretty staggering string of bad luck.
It really does.
We are looking at the late 1990s and the early 2000s. You have these two relatives, Remedios and Angelita Antonino, and they placed over 150,000 US dollars into time deposits at a BDO branch in Makati City.
Which was a lot of money back then, still is, but especially then.
Still is, exactly. Now, because they were green card holders who spent the vast majority of their time living in the United States, they needed a hands-off investment strategy.
Right. They couldn't just pop into the branch every week.
No, exactly. So they set up an automatic rollover agreement with the branch manager. The idea being, when the time deposit reached its maturity date, the bank was instructed to just automatically renew it.
So the principal and the accrued interest would just roll over into a new term.
Right.
It allows the money to continuously compound while they're, out of the country, which, by the way, is a very common wealth-building tool.
Yeah, you just lock the money away, let the interest do the heavy lifting, and don't touch it.
Exactly. But the logistical nightmare here really starts with how the Antoninos decided to protect their paperwork.
Oh, man, yeah.
Because the physical proof of these investments, the actual time deposit certificates, those were crucial documents. They didn't just, leave them in a desk drawer at home.
They rented a safety deposit box to keep them secure.
Yes. But the problem is, they didn't rent that box at BDO. They rented it at an entirely different banking institution, Banco Filipino.
Right. And anyone who is even remotely familiar with Philippine financial history knows exactly where this is going.
Oh, yeah. It's infamous.
Banco Filipino eventually suffered this massive institutional collapse. They declared bankruptcy, the central bank had to step in, and the Philippine Deposit Insurance Company, the PDIC, they took over the liquidation process.
So from the perspective of an everyday customer, like the Antoninos, the branch holding their safety deposit box was entirely frozen.
Just locked down.
Literally locked down. The assets were frozen, and they were legally barred from accessing their own physical documents.
Which is terrifying.
It is. And it took an excruciatingly long time for the regulators to untangle the mess of a bankrupt bank. The Antoninos they weren't able to retrieve their physical certificates from the receivership until 2011.
Wow. So that is a massive gap in time where they had zero access to the proof of their investments.
Right.
But okay, they finally get their documents out of the vault. It's now 2014, and they head over to BDO to check on the status of their auto-rolling time deposits.
But then they hit another wall.
Right, because the specific BDO San Lorenzo branch-like, the actual brick-and-mortar building where they originally handed over the money, it had permanently closed down.
Right. So they are forced to go to the nearest open branch to make their inquiries. And, the bank staff naturally needs time to investigate records from a closed branch dating back over a decade.
Which makes sense.
Sure. So months pass. The Antoninos send formal demand letters in 2015, trying to get an update on their funds. And finally, BBO responds with an absolute bombshell. The bank claims that 3 of those time deposit certificates, amounting to a solid $100,000, were already redeemed and paid out on May 28, 2001.
See, I find this claim completely baffling. Because, think about how a certificate of time deposit actually works. It's essentially a golden ticket.
Right.
The bank's own terms and conditions, which are printed clearly on the back of the certificate itself, they mandate that you must physically surrender that piece of paper back to the teller to get your cash.
Exactly.
So if the Antoninos still had those physical golden tickets, and those tickets were literally locked inside a frozen vault at a bankrupt bank across town, how on earth could BDO have handed over $100,000?
That logical paradox is the exact dispute the Supreme Court had to resolve. I mean, the physical evidence completely contradicted the bank's internal narrative.
So how did BDO defend themselves?
Well, to defend their side, BDO relied heavily on their computer-printed history data. They argued that their digital ledger showed a zero balance, which to them proved the money was withdrawn.
But a computer can just be wrong.
Right, so to support the computer data, they produced a document known as a demand draft. And according to the bank, this draft was signed by Angelita Antonino on May 28, 2001, effectively authorizing the massive withdrawal.
So the bank is leaning entirely on this one signature.
Entirely.
But the Antoninos had an absolute trump card here. Because Angelita could not possibly have signed that demand draft in Makati City on May 28, 2001.
No, she had the ultimate alibi.
She wasn't even in the country.
Right, she presented a completely airtight defense. Angelita submitted an official certification from the Philippine Bureau of Immigration, and she backed that up with the physical entry and exit stamps in her actual passport.
Which is hard to argue with.
Impossible, really. This documentation proved without a shadow of a doubt that she left the Philippines in November 2000, flew to the United States, and did not set foot back in the Philippines until June 2003.
Wow.
She was thousands of miles away on the very day the bank claimed she was standing in their lobby withdrawing $100,000.
Okay, so faced with literal government immigration records, BDO must have realized their computer system was wrong, right?
You would think so, but they actually doubled down.
Really?
Yeah, they tried to argue against the passport stamps. They claimed that the Bureau of Immigration certification was based on a, quote, computer database file that might have been incomplete or flawed.
Oh, come on. So their computer's perfect, but the government's computer's flawed.
Exactly. And the Supreme Court dismantled that specific argument by relying on fundamental rules of evidence. To understand why BDO's argument failed so spectacularly, we have to look at how the law treats government documents.
Oh.
There is a legal concept called the presumption of regularity. So think of a referee in a professional sports game.
Okay, I'm with you.
We operate under the baseline assumption that the referee is watching the play and enforcing the rules correctly. The law affords that exact same baseline trust to public officials performing their duties.
So, because the Bureau of Immigration officer is a public official, the law automatically assumes their database and their certifications are accurate.
Yes. The facts stated in that official document are considered prima facie evidence.
Prima facie, right.
Meaning they are accepted as correct on their face without needing further proof. If you want to challenge that document, like if you want to argue the referee blew the call, you cannot just stand there and guess that they might have blinked.
You need proof.
You must present clear, convincing, and physical evidence that the system failed. BDO brought absolutely nothing to the table except a hypothetical theory that the immigration database might be missing data.
So the court just threw that argument out.
Completely threw it out.
And it's not like the Antoninos stop at the travel records either. They brought in a handwriting expert, right?
Yes, from the Philippine National Police Crime Laboratory to examine the signature on the bank's demand draft.
Right, Police Lieutenant Magay. And he testified that there were significant differences in the spacing, the alignment, and, the execution of the signature compared to Angelita's actual handwriting.
Now, the bank did try to poke holes in the expert's testimony.
Because it was only a copy.
Right, exactly. Because the expert was only examining a carbon copy of the demand draft. Handwriting analysis relies heavily on microscopic details like the pressure of the pen, the hesitation marks, the way ink pools at the end of a stroke.
Sure, and a carbon copy obscures all of those minute details.
Right, making a 100% definitive conclusion impossible. However, the experts still concluded that the signatures were highly likely made by two different people.
I mean, when you combine that professional forensic opinion with the physical impossibility of Angelita being on the continent, the bank's entire narrative just falls apart.
It really does.
Okay, let me play devil's advocate for a second. Let's assume an imposter walked into that branch pretending to be Angelita. They still wouldn't have had the physical time deposit certificates because those were locked in the Banco Filipino vault.
Right.
And if a bank's own internal rules require the physical certificate for a withdrawal and the imposter doesn't have it, the bank must have required them to fill out some kind of sworn statement,
Yeah.
like an affidavit of loss, right?
It is exactly what is supposed to happen.
So I assume BDO just pulled that affidavit out in court to explain why they bypassed their own rule.
They did not.
Wait, really?
No, the Supreme Court noted that BDO's former officer in charge actually testified about their strict standard operating procedures. If a depositor wants to redeem an investment but claims they lost the physical certificate, it is mandatory that they execute an affidavit of loss.
Okay, so where was it?
When the court demanded to see this highly critical document for a $100,000 transaction, BDO claimed they had destroyed it.
You're kidding.
They argued that their internal retention period for supporting documents was only 10 years. And since 13 years had passed, they claimed the paperwork was simply unavailable for examination due to, quote, the passage of time.
That is staggering. So a bank processes a massive withdrawal without the mandatory physical certificate. They accept a suspicious signature from a woman who is demonstrably out of the country, and then they conveniently shred the one piece of paperwork that supposedly justified the rule breaking.
It's a bad look. And this specific chain of failures brings us to the bedrock principle of banking law that the Supreme Court really emphasized in their ruling.
Which is what?
Well, running a bank is not like running a retail store or a restaurant. The banking industry is deeply imbued with public interest. So the law imposes a fiduciary duty on them.
Meaning they hold a position of extreme trust and responsibility over other people's assets.
Exactly. In a normal business contract, the law typically requires a person to exercise the diligence of a good father of a family, which is basically legal shorthand for ordinary, reasonable, everyday care.
Just standard caution.
Right. But banks are mandated by law to operate on a completely different level. They must exercise the highest degree of diligence. They are legally expected to demonstrate meticulousness and provide irreproachable service.
So if you are listening to this and you're worrying about the money sitting in your checking or savings account right now, this is the legal safety net protecting you.
Yes.
The law demands that your bank be near paranoid about protecting your funds. And BDO's failure to verify the true identity of the person signing that demand draft and their glaring failure to secure and retain an affidavit of loss, I mean, that wasn't just a minor administrative oversight.
No, it was a massive breach of that highest degree of diligence. They ignored their own safety protocols, and the court held them fully accountable.
So how did BDO react when they realized their evidence about the withdrawal was just fundamentally flawed?
They actually pivoted to a completely different legal strategy. They abandoned the argument of how the money was taken and instead focused on when the Antunos complained. Yeah. BDO invoked a defense known as lashes.
Lashes. Okay, I've heard this term thrown around in legal disputes. It's essentially a use it or lose it countdown timer.
Right? That is a perfect way to visualize it. Lashes is a doctrine of equity. It argues that if you fail to assert a legal right for an unreasonable and unexplained length of time, the law basically presumes you have abandoned that right entirely.
So, like, if someone leaves a broken down car on your front lawn,
Right.
and if you don't complain about it for 10 years, a court might say, well, you've lost the right to suddenly demand it be moved.
Exactly. So BDO looked at the 14-year gap between the deposits and the Antoninos' formal demand letters and said, look, if this was really your money, why didn't you check on it for over a decade? You slept on your rights, therefore you abandoned the investment.
But the Supreme Court forcefully rejected that timer, didn't they?
They did.
And the reason why is crucial for anyone who utilizes long-term investment strategies.
Yeah.
The Antoninos had an automatic rollover agreement.
Yes, and the very nature of that investment completely defeats the lashes argument. When a time deposit matures, the 2019 Manual of Regulations for Banks, which is issued by the central bank, clearly dictates that if it is not withdrawn or explicitly renewed, it automatically converts into a savings deposit and continues to earn interest.
Ah, I see.
The Supreme Court ruled that it is legally impossible to, abandon an investment instrument that is specifically designed and contracted to continuously generate earnings over time. The money was actively working, compounding interest year after year.
I mean, you don't abandon an oak tree by planting it in your yard and letting it grow untouched for a decade. That's the entire point of planting it.
Exactly. And the court issued a very stark warning regarding BDO's argument here. If the justices had accepted the Lash's defense, it would have set a incredibly dangerous precedent.
Oh, absolutely.
It would signal to the entire financial sector that banks could simply seize long-term compounding investments if a customer didn't, walk into a branch and knock on the counter often enough.
It would create a massive loophole for banks to quietly absorb dormant wealth.
Right.
Well, it is a massive relief they struck that down.
Yeah.
But as we look at the final tally of this legal battle, the Antoninos did not win everything, did they?
No, they didn't.
There's this very specific, somewhat painful legal nuance regarding their very first deposit. They successfully won back the $100,000 from the deposits made in 2000 and 2001. But they actually lost their claim for an initial deposit of over $50,000 made back in 1998.
Yeah.
And the reason for that specific 1998 transaction, they only possessed an official receipt. They did not have this physical time deposit certificate.
In the trial court, the appellate court, and the Supreme Court, they all unanimously agreed on this point. In commercial law, an official receipt is entirely insufficient to substantiate a claim for a time deposit.
Okay, I have to challenge this logic
Yeah.
because to an everyday consumer, this feels incredibly unfair.
It does feel that way.
If I go to a big box electronics store and I buy a massive flat screen TV, that printed receipt is my ultimate proof of ownership. If a security guard stops me at the exit, I show the receipt and I'm allowed to walk out with the TV.
Yeah.
Why is a bank receipt suddenly not enough to prove I own the money I handed over to the teller?
Okay, think about what that TV receipt actually represents. It is proof of a transaction that is completely dead and finished in the past.
Right.
You handed the cashier money, they handed you a television. The relationship is over the second you walk out the sliding doors.
Yeah.
A simple bank receipt functions the exact same way. It only proves that cash changed hands at a specific moment in history. It does not prove what happened next.
But a certificate of deposit is different.
A certificate of deposit proves a transaction that is alive. It is a living contract for the future.
Okay, I think I see where this is going.
Right. It is a formal written acknowledgement by the bank that they received your money, combined with a specific promissory note that creates a debtor and creditor relationship. That certificate dictates the interest rate, the maturity date, and the specific terms under which the bank promises to pay you back.
So the receipt proves the Antoninos gave BDO $50,000 in 1998. But without the living contract, the certificate, they have no legal way to prove the specific terms of that deposit, or even if the money was meant for a time deposit at all.
Exactly.
For all the court knows, that $50,000 could have been paying off an old loan or something. The receipt alone doesn't prove the money is still sitting in a vault waiting to be claimed.
And because the Antoninos anchored their lawsuit on the claim that a specific 1998 time deposit existed and was wrongfully withheld, the official receipt simply didn't carry the legal weight required to prove their case. Missing the correct paperwork cost them $50,000.
Wow. That is a brutally expensive lesson in document retention.
It really is.
Let's look at the final verdict then, and how the Supreme Court addressed the damages. Because the court ordered BDO to pay back the $100,000, plus the agreed interest accrued from the maturity dates until fully paid. But they went significantly further, hitting the bank with heavy financial penalties to send the message.
They did. And the way the court structured these damages really highlights how the justice system regulates the banking sector. First, they awarded moral damages, which were set at 100,000 Philippine pesos.
And the Supreme Court actually had to step in and fix a clerical error from the lower appellate court regarding these moral damages, didn't they?
Yeah, they did. The lower court mentioned moral damages in the body of their decision, but somehow neglected to put it in the final binding order.
Oh, wow.
So the Supreme Court fixed that, and they clarified that moral damages are not designed to punish the bank. They are designed to directly compensate the victims for physical suffering, mental anguish, fright, and serious anxiety.
Which makes sense.
The justices recognized the sheer, suffocating panic of suddenly being deprived of your life savings due to a bank's negligence.
Okay, so that covers the emotional toll. What about punishing the bank's actual behavior?
That is where exemplary damages come in. Those were set at 300,000 Philippine pesos. Under Philippine law, exemplary damages act as a corrective penalty.
Right.
They are imposed specifically for the public good. Because banking relies so heavily on public trust, the court uses these damages to make a highly visible example out of BDO. It is essentially a financial spanking designed to force the entire banking sector to maintain that highest degree of diligence we discussed earlier.
And finally, the court awarded attorneys fees of 150,000 pesos, recognizing that the Antoninos were forced to endure a grueling decade of litigation simply to protect their own money.
And on top of it all, a 6% legal interest on the total judgment award from the time the decision becomes final until the bank actually cuts the check.
It is a comprehensive ruling that perfectly illustrates the massive legal burden placed on financial institutions. The required standard of care is perfection, or at least as close to it as humanly possible, because any failure threatens the stability of the entire system.
Absolutely.
Well, as you look at your own finances and the institutions holding your wealth, there's some very clear practical takeaways here. Protect your physical banking documents relentlessly. Understand that a basic receipt is just a snapshot of the past, while a formalized certificate is a living contract for your future. And you can sleep a little easier tonight knowing that the justice system holds banks to an almost uncompromising standard to protect your hard-earned money. If they fail to be diligent, the courts will hold their feet to the fire.
Well said.
But I want to leave you with a chilling modern dilemma to think about. In this specific case, dealing with transactions from the late 90s, it was the physical paper time deposit certificates and the physical ink-stamped passport that saved the Antoninos from ruin. Tangible evidence defeated the bank's digital records. But look at the direction the world is moving. We are racing toward completely digital, branchless banking where there are absolutely no paper certificates issued. Your entire life savings, your future, is increasingly becoming nothing more than a line of code on a bank server. If the day comes when a bank's computer suddenly glitches and claims your account is empty and you have no physical paper to fall back on, how will you prove what is rightfully yours?